The Court of Appeal sitting in Benin was packed out, and the legal team of the appellants and respondents were in court to witness the proceedings. Addressing the three-man panel of justices led by Justice Olukolade Bada, counsel to APC Lateef Fagbemi SAN informed the court that they have a counter application against that of the appellants. He said the application is challenging the order of the tribunal for the recount of ballot papers, and another application stopping the tribunal from allowing the completion of the counting of ballot papers against the background of the appellant's application. On his part, counsel to the petitioners Yusuf Ali SAN, who said time is of the essence in the matter, said the tribunal has used more than 150 days from the 180 days allocated for the tribunal, adding that since they were the first to file an appeal, the court should entertain the petitioner's application, maintaining that if the third respondent wanted the application to be entertained early enough, they should have filed the application well on time. On his part, counsel to the third respondent Wole Olanikpeku SAN said the application made by the third respondent for the consolidation of application by both parties is harmless, adding that if the petitioner's appeal is heard by the court, then the court will have to adopt the application of the third respondent and pray the court to entertain the application, since the two applications filed by the petitioners and the third respondent are already before the courts. Chairman of the appellant court, Justice Olukayode Bada, said since there is limited time, there was need to expedite hearing on the applications. After addressing all the parties, counsel to the petitioners Yusuf Ali SAN said he will file a brief on Wednesday, since he was only served the motion on stoppage by the third respondent while at the appeal court, adding that they will be at the appeal court on Thursday for the court to hear the two appeals. Chairman of the panel of justices, Justice Olukayode Bada, said it would be better for the appeal court to sit on Friday, as according to him, the appeal court will entertain 25 different appeals on that day. However, Yusuf Ali SAN said Thursday will be better, as all parties in the case will each address the court in not more than 10 minutes. Based on this, the court adjourned till Thursday this week to hear the application. Counsel addressed newsmen.
Their own application was that the two appeals, the one filed by us and the one filed by them, should be consolidated. That is, they should be matched together for hearing. Our own appeal was the one in which we are contesting the tribunal's order for closing us, that is, stopping the recount of the ballot papers. Their own appeal was that the tribunal should not have even given us order at all to count.
There are two appeals before the Court of Appeal, one by the petitioners, then one by one of the respondents. Two applications relate to the rulings of the tribunal and appeal and cross-appeal.
The ballot papers that were ordered to be counted were not tendered in evidence. So it's not an exhibit. Our concern is, why should the court or the tribunal order a recount of a document or documents not admitted in evidence?
The journey to the Court of Appeals started on the 10th of February 2017 when counsel to the second respondent, Ken Mozia SAN, objected to the recounting of ballot papers for Ego, Akoko Edo, Esako East and Esako West. According to him, the 14 days given to the petitioners elapsed at that time. However, counsel to the petitioners, Malam Yusuf Ali SAN, told the tribunal that since the tribunal chairman had ordered the recounting of the ballot papers, there was need for it to be concluded. According to him, the tribunal has set a precedent that in the course of trial, results must be achieved. He pointed out that witnesses who were cross-examined for 4 minutes were allowed to answer a question that was put before them, even though the time given to them had elapsed. It was based on this that Malam Yusuf Ali SAN told the tribunal that the recounting of the ballot papers should be concluded. However, counsel to INEC Onyinye and Monye, counsel to APC Lateef Fagbemi SAN, and counsel to Governor Godwin Obaseki Kemozia SAN objected on the grounds that the petitioners cannot set the pace at which the tribunal will decide on issues. They said the petitioners had 14 days given to them, and it would have been enough for them to count the ballot papers. In his ruling at that time, chairman of the tribunal, Justice Ahmed Badamasi, said he had no power to add just 1 minute for the petitioners to continue the exercise. It was based on this ruling that the petitioners proceeded to the Court of Appeal in Benin to challenge the ruling by the chairman of the tribunal. The three-man justices in the Court of Appeal sitting in Benin had adjourned sitting to Thursday this week to entertain the application filed by both parties. From the appeal court sitting in Benin, Best Mbiere reporting.